I'm writing a appeal brief for my case against the state attorney in Sarasota, Florida, 12th Circuit Court. Uh, Wanted to process some thoughts at this point. The judge, all of the trial court judges dismissed the case with prejudice, uh, and it's very basic human fear. The matter in the law is completely obvious. It's a death penalty offense to sexually injure a child, to injure a child upon their sexual organs in Florida is a statute. It's in my appeal. And so what the doctors are doing falls clearly under that, under that statute. Uh, because the effect on the child is the same, no matter who is attacking it. You often hear this from Christians. And of course, people are mad at Jews about this, but um, only about 97% of the circumcisions in Florida, the United States as a whole, are done at the behest of cultural Christians. And on top of that, when I say cultural, secular or observant. Um, and even if people deny Christianity altogether, or don't feel they're Christian at all, you grew up in the milieu of Christianity, and so there's that cultural aspect. Is what I'm speaking of. And then when you look at Judaism, you find that they're famous for announcing many of them that they are secular Jews. They, I suppose, means they're ethnically Semitic, and they grew up in the milieu of the Torah, but they don't identify with uh, mythology literalism, if you will. Um, so, on top of that, you know the heavy hitter intactivists are Jewish. So it doesn't matter. Religion doesn't matter. Ethnicity doesn't matter. The rule of law matters. This is the new covenant, if you will, is equal protection in the United States. Um, so, and Islam, which is less than 1%, I I, th- I think in the United States, they're only concerned really because it's not mentioned in the circumcision is not mentioned in the Quran. Their concern is cleanliness and uh, you know it's a personal responsibility. Cleanliness is a personal responsibility. You know that ostensibly women more time uh, and effort and expense in the cleanliness of their own genitalia than men, uh, for obvious reasons. And they have a whole row at the drugstore for feminine hygiene products. So they could have a small little shelf if men are so, because there's always a company that will, if there's a market, they'll either create one that doesn't exist yet, or certainly if it starts, marketers come pouring in. Um, so did I say that Christians are famous for saying, well, we don't do it for religious reasons, that they feel lands them squarely into the New Testament zone and out of the Old Testament zone. And again, you have this problem of them making a distinction without a difference because the effect on the child is the same, um, no matter what you've got going on in your head. So, and of course, the idea that the child recovers, the doctors, the the symptoms of distress resolve themselves when the check clears is simply not true. That kind of a trauma changes gene expression, and that changes, I think it has to do with protein production, and it dysregulates the individual. Point in case found in my short book, Jesus and the Unabomber. So let me see what else. So the civil court judges uh, actually end up acting like cartel bosses, and granted, the what you get for equal protection in the United, what you give up for equal protection in the United States is, this idea of the sovereign citizen. No, you live in a country that has jurisdiction of control, and so it's just a matter of fact. And so what you get for what you lose is you get equal protection, and that's it's the same with all technology, if you will, that Ted Kaczynski was. So again, it's for good reason, or technologists, which for Jesus are takers of thought. They quite thoroughly wrecked him. Forgot the point that I was about to make. Anywho, yeah. So the trial court judges are cartel bosses, and it's the problem is that they set themselves in direct opposition of the rule of law. It's a really, really strange thing to encounter and to be a part of. Direct opposition. Well, they want to pass it to the appellate courts. First of all, they simply don't feel like they have the authority. But it's not only do they have the authority, they sworn an oath to the U.S. Constitution and the state constitution. So I've got 2 cases already in appellate courts. I've had 5 cases altogether. 2 have ended against me in really superfluous, ridiculous kind of endings. The first one in the federal court, which I was quickly going up the learning curve and got a little bit lost in that one. And then one against Sarasota Memorial Hospital, where the judge said the matter's not considered outrageous in a civil society when he dismissed my case. Dude, you do not live in a civil society, and it just goes to show how far out of touch you are with the external reality. So, like I say, 2 already in appellate court, and the third one I've just received a case number for the appeal from the appeal court. I think it's the Second District Court of Appeals in Tampa. But it's maddening, in the Madden in the case in the Panhandle, the First Circuit, the young defense attorney, Assistant Attorney General of the state of Florida, I think, just flooded her answer to the appeal with all these case citations that had nothing, that just were completely differentiated. They not even close, and it was just in desperation, throwing dust in the air and hoping it'll get in the eyes of the appellate court justices. But it settles quickly, and the matter is there still in stark relief. Boy, the idea that you restrain someone, it's called criminal restraint, and cut on their healthy body is just crazy. It's madness. Right. So anyway, the analogies were foot binding in China, which ended in 1911. It had been around for 1,000 years and was very, very widely practiced. Starting when the girl was 6 to 8 years old, they'd start, you know, tightly binding her feet, breaking bones, crippling her for life. But it was considered cute, quaint, just like circumcision. Um, and then there's also the witch burning, the Salem witch trials. And this was before the formation of the United States. And, when they got over that madness, the judge and several other people, they didn't suffer any penalty, but they apologized for getting carried away. So hang on a second. Well, anyway, a lawsuit was filed in Oregon. Same thing, and you can see it at intact.global/conference. It's probably linked on several pages. The actual complaint, and or just Intact Global. Look it up, and you'll find the website. And they just make the same point over and over. Oregon is an equal protection state, and yeah, that's it. If you try and do such a thing to a grown person, of course, you run right into a buzzsaw, forcibly restrain them and start cutting on them with a knife. Or a defenseless female child, subject to very severe consequences. And what's still going on in the United States, it falls really squarely into the category of witchcraft. Not to mention in the Torah, witches are supposed to be murdered. There was 24 commands to kill in the Torah, and they've all been set aside. And the reason is, in every case, the person going out to do the good deed may have run straight into a buzzsaw and been the one that did not make it home alive. So you just have this one defenseless person left. It's not a command to kill, but it's a command to cut. And, Judaism, again, most Jews more than ready to see this set aside. But they have, in the observant Jews, this concept called tikkun olam, which they have a duty to help repair the world. So they should have let go of this a long, long time ago. And it's funny, again, talking about Judaism, because in the United States it's to about 2% of the circumcision. Also, I should mention that in Florida, the last, I think, reliable data, it could be more recent data, but 2005 or 2008 was that 37.5% of children are circumcised. So of those, say 38%, 2% are Jewish children. They haven't chosen their religion yet. They're children of Jewish parents, and 97% are children of cultural Christians. So it's really weird stuff. But again, demonstrating that nothing to do with religion, has no bearing on the enforcement of the Constitution. This is why the church and state are separate, so not one religion doesn't go crazy and decide that they're going to burn witches or enslave black people or bind the feet of female children, et cetera, et cetera. I think it's the saddest thing of all that the state attorneys are, like the trial court judges, are scared to death. It's really a self-interest thing. You're afraid that you won't get voted again in the next election. And it's that simple. It'll affect your income stream, which affects your household and your retirement pension and everything else. Um, so the state attorneys, but if the state attorneys went to the hospitals with an order from the court in hand, look at, hey, I hate to do this to you, my friends, but I've got to because, here's the paper from the court. It's real simple. Just cease and desist. And that's the end of it. And if you don't cease and desist by, of course, tomorrow morning, then you're subject to criminal arrest and et cetera. So that order that they need to bolster them must come from the court. And hopefully one of these 3 appellate cases will be remanded with instructions for declaratory judgment. There's no sense in having a trial. They'll get embarrassed in a trial. Their answers to my complaints are already, well, they haven't given an answer. They just make these motions to dismiss and throw dust in the air. And the judges latch onto it because they're scared to death. So, like I say, one of the appellate cases may result in the right answer. I just do not understand their difficulty. People will respond appropriately to instructions from an authority figure. In the United States, the authority figure is the court. The legislature made the law. There's a whole slew of laws. You cannot batter another person. It's a crime. And adult, child, doesn't matter. But in addition to that, because children are defenseless, they make extra laws for them, restating and restating and restating that if you harm a child, you get in serious trouble. So the legislature made all these laws, and if the executive branch doesn't enforce them, then the court has to step in. And the judge says, oh, it's a separation of powers. No, that's the whole reason. Checks and balances is the whole reason for the 3-part government. And there. All right, that may be enough for now. I'm going to go back inside and keep writing. It's well along. My appeal brief, my initial appeal brief is well along. Because I've been doing this for so long. It's just all extemporaneous at this point. I just sit down and regurgitate the same stuff over and over. Doubling down at every turn, at every rejection, I do tend to double down. So now the trial court, the 12th Circuit, produces the case file for the appellate court. And I don't need to wait for that because I also have the document identification numbers. So not every circuit court does it this way, but you sign into my Florida court access. Or no, that's where you file. Into ClerkNet 3, which not all of them use it, but the Sarasota Circuit does, and see everything that's been filed on the docket. And so all I need is document identification numbers to proceed with my filing of the appeal brief. I don't have to wait for the lower court to produce the case file, which, who knows, 2, 3, 4 weeks is in this type of thing. It's not considered a long time. All right, so go to Intact Global and look at the Oregon case. It's 72 pages, but it's just a child screaming. It's just the child screaming. It's very allegorical. I read it twice already, and we'll probably read it again because it hasn't changed my approach much. I don't know if there's a line or two that I can mimic in there, but those attorneys that wrote that, super smart people, and one, 30, 40 years of experience, and one, undergraduate degree in physics, as smart as a whip and a juggernaut. It won't be stopped. And losing my son. And they got us a second year law student to clerk for them and just do a lot of the writing, the labor, if you will. And then on top of that, and a fourth attorney, the clerk is not yet an attorney officially. The fourth attorney is the Oregon counsel, and he's got a lot of years in the biz and has done some very serious civil rights work. There was something I was going to mention. Not only Eric Klopper, who's really the lead, I don't know if you say that. He signed the complaint, and he's the director of Intact Global. And but there's also Steven Svoboda, whose writing I always appreciate. I was going to say something. Hang on. Well, Steven is the director of ARC Law, ARC, which is Attorneys for the Rights of the Child, arclaw.org. He's written extensively on this topic. I'm reading one of his articles right now. 3/4 weren't normal. It was a reference to some quack doctor that was promoting circumcision. But hold on, hold on. Thoughts come and going. Oh, right. It was just interesting to me that Stephen also has, I think, a bachelor's and a master's degree in physics, and then went to Harvard Law School and does work in patent law, which to me that was because I did go through Patent It Yourself one time, and the book and the process, and I found it exceedingly, difficult, kind of upside down and backwards, the way you're including all you can in your claim and excluding at the same time everything that you can, it seemed to me. Yeah. Lots of list processing, which is a computer programming language, and which I find is kind of the way the law is. It's just much like mathematical proofs. You're just starting with certain axioms and building up to a proof of a concept. All right, that definitely was enough.